Now welcome to lesson number 11 in the Miracle of America. And this one deals with Article 3 of the Constitution and is about the Supreme Court, the guardian of the Constitution. You know, when the Founding Fathers first set up the Articles of Confederation, they didn't trust the central government with setting up any kind of a judicial system. They just felt that the state's courts could handle everything. And so that's the way they left it. But it wasn't very long before they realized that there were some very serious problems that could not be handled by the state courts. And now that brings you to your outline and lesson number 11 now, with point number 1 there in the introduction. There were those, for example, who were ambassadors in this country and had problems of international dimensions. They didn't want those settled in state courts. That's your first blank. State courts. No, indeed. They wanted a higher level of courts. There was another problem, and that's dispute between two states. In which courts of which state are they going to settle those? No, you needed something higher than the state courts for that. And then there were interpretations of the laws. Who's going to interpret the laws that Congress passes? If every state in the Union does it, you'll just have absolute chaos and confusion. We needed a single interpreter of our federal laws and the Constitution and our treaties. And then number 4, what about the United States government being sued or involved in cases? How's that going to be settled in a state court? Nobody's going to allow the state court of one state to handle a United States government case handling in which all of the other states will have to take the decision. Then what about things that are not within the jurisdiction of a state, like crimes on the high seas? What state court is supposed to handle it? You see, it wasn't long before it was very apparent that they needed to go for a federal judiciary system. And so, in the convention, they all agreed that in Article 3 they would provide for a great judiciary that would be above the individual states. But they had a problem. There wasn't any system like this anywhere in the world. And so how would our national government judiciary system be set up? They decided to make it pretty simple. And so that's what they did. There are only 4 provisions in the Constitution for our federal judiciary system. And capital A under 1, a Supreme Court. They all agreed there should be one final top supreme judicial body. That's what we call our Supreme Court. And then secondly, there would have to be a lower system of lower courts or inferior courts. So your second blank is lower, a system of lower courts. All right? Then one other thing they wanted. They didn't want the judges to be able to be intimidated when they happened to make a decision that was at the moment unpopular. And so they wanted them in there for life. You couldn't remove them just because you didn't happen to agree with them at the moment. And so they wanted them for life. That's your next blank. And they wanted their salaries to be fixed so that they couldn't be intimidated and accused of having done something unpopular, and therefore their salaries would be reduced. And so fixed is your final blank there. All right, now capital B. What kind of cases are you going to assign to our federal courts? And so here are 11 of them. And I just want to go through them briefly for you so that you'll see what goes into the federal courts and why. First of all, I think you'll agree that anything that has to do with the interpretation of the Constitution ought to go there. And so that's your first blank, Constitution. Constitution. Now, how are we going to interpret the Welfare Clause? How are you going to interpret the Commerce Clause? You see, that should go to the federal courts. And then everything that has to do with the interpretation or enforcement of the laws of the United States, and that's your next blank. If it's the laws of the United States, we're going to have it up on the federal level. And then how about disputes over treaties and things that are going that are problems with foreign nations. So disputes between ourselves and foreign nations over treaties, etc., should be federal. And then anything involving the ambassadors or representatives of foreign governments, surely that should also be there, foreign governments. Then how about crimes on the high seas? I mentioned that a minute ago. You see, no state knows whether or not it has jurisdiction. So the Congress fixed that on the federal level for all maritime cases and letting Congress decide what would happen in cases of crimes on the high seas. And what about cases where the United States is being sued? Yes, that's number 6. That definitely should be on the federal level. And then disputes between two states. All right, that should be on the federal level. They won't be able to agree on which state court that should be decided, that's for sure. Now we come to a ticklish one. Number 8, disputes between a citizen of one state suing another state. What about that? Here's a citizen that wants to sue another state. Can he do that? And if so, should it be in federal court? And the founders thought, yes, I guess they should. But when they, right after the Constitution was adopted and put in operation about 1793, Mr. Chisholm up in North Carolina sued the state of Georgia for some money it owed him. And Georgia said, look, you can't sue us without our consent. We're a sovereign state. We can't be hauled into federal court and sued by a citizen up there in North Carolina. But that's what the Constitution said. And so I want to tell you, they got together in a hurry and amended the Constitution so that couldn't happen anymore. That's the 11th Amendment. The 11th Amendment is your blank. All right, now number 9, what about the disputes between the citizens of two different states? Which courts will they sue in? Well, if it's a petty case, why, they have to work it out however they can. If it's over $10,000 and they're from different states, it's true, they can go into federal court. So $10,000 is your blank. Then there's sometimes citizens of the same state who are arguing about mining and land claims in another state or other states. Yes, they agreed that should go into the federal courts. And last of all, where you're suing somebody from a foreign country, or you're suing a foreign country, or a state is in trouble with a foreign country, that should be settled in a federal court. I think you'll agree those are about the 11 areas that needed to be considered, and that's the way the Founding Fathers decided them. All right, let's go to capital C. When the system was finally set up, the whole federal system was finally arranged and programmed, justice was established on 3 levels. First of all, the district court. The district court, that's number 1. And what if people aren't satisfied with what happens in the district court? You see, they started out with just 1 district court in each state, but we have nearly 100 of them now because of our population increase. If people aren't satisfied, then they can go to the Circuit Court of Appeals. And there are now 11 of those. Actually, there are 10 districts around the country and the District of Columbia, which makes a total of 11. Then at the very top, of course, is the Supreme Court. Now, there's some interesting things about the Supreme Court. First and foremost is the fact that there are 2 kinds of cases which begin and end in the Supreme Court. They don't go to any district court or Circuit Court of Appeals. And that's, first of all, cases involving the representatives of foreign powers. Obviously, they should be brought right in where the matter can be handled summarily because it involves our relations with foreign countries. It mustn't be dragged out forever. That can go right into the Supreme Court. And if one of our states is involved in a case on a federal matter, it too goes into the Supreme Court. And so your number 2 there was, and under number 3, the Supreme Court, we have number 1, cases involving foreign powers, their ambassadors and ministers, and number 2, states. Now, the Supreme Court doesn't review everything that's sent to it. That is, I should say it doesn't have hearings on all of them. Each year they get about 5,000 appeals. And they review them, but 4 of the justices have to agree that it's important enough for the Supreme Court to hold hearings or analyze them before they really give it concerted attention. 4 of the justices have to feel that it's that important. And they hold secret meetings every week between about October and June when they're in session, and then they decide which ones they will hold hearings on. And usually they end up with around 200 per year that actually get the treatment. All the other cases are settled finally. The Supreme Court will not go any further with them. Then the lower court decisions are completely controlling. All right, number 4. Did you get 200 there on B on your outline? About 200 a year they actually analyze and hold hearings on. All right, number 4. Congress is authorized to set up additional courts as needed. Now, these are called special courts, and they're the ones that have a great deal of technical special litigation. For example, we have a tax court, a federal tax court. In case you don't agree with IRS and you take it up through its appeal channels, it'll come up to the tax court. And then we have courts on customs and on patent appeals. And if you're suing the government, we have a court of claims. These are all part of the lower courts that the Congress was authorized to set up, and they're called special courts. And that's your blank. Now, number 5 on your outline provides that all criminal cases will provide a jury for the accused. He is entitled to a jury, and that means that his case will be heard by 12 people, 12 of his peers, and they have to come to a unanimous decision before he can be considered convicted of the offense. And now, actually, they didn't provide for damage suits. Now, those are civil cases. And so in the Seventh Amendment, that was put in. If it's a damage suit in a federal situation for more than $20, you get a jury there also. That was just left out of the main Constitution, had to be put in the Seventh Amendment. Now I want to mention something very interesting. When the Founding Fathers were setting up these judicial powers that were to go to the federal government, they didn't want to include general policing powers. They didn't want any national police force. They wanted the federal government to be able to investigate their areas of responsibility and offenses, but they didn't want them out patrolling around in a very massive national police force. That's very important to understand because that comes up every so often. Someone says we ought to have a national police force. Now here are the areas. Under A there, you'll want to insert police. No, they didn't want them to have general police power. Investigative power, yes, but not general police power. For example, they can investigate crimes on the Indian reservation. That's one. They can investigate counterfeiting because that's a federal problem. And they can investigate robberies of federally insured banks. The FBI will move in there immediately. And they have a tremendous success record for solving those bank robbery cases. Now, number 4, we have interstate crimes. Now that's where the loot or the victim is carried across state lines. Immediately that comes into a federal jurisdiction to investigate. But they're not out policing around to prevent those crimes from happening. But if they do happen, they have jurisdiction along with the states that were involved, and they usually work it out together to see how the interests of justice can be best satisfied. For example, you have the interstate transportation of stolen goods. Somebody steals a lot of furs in Missouri, carries them across over into Kansas. The FBI has immediate jurisdiction to investigate that. And crimes relating to national security, spies, espionage, sabotage, that's another FBI area of activity. For example, the Alger Hiss case, that was a federal case because it involved a violation of the security laws of the United States. And the Rosenberg case, the stealing of secrets from Los Alamos in connection with the atomic bomb, etc. Then B, the states are extremely anxious to prevent a general police force being developed, as I mentioned to you. And so when they tried to set one up during the gangster era, they wanted J. Edgar Hoover to be the head man for a national police force. And guess what happened? He went up before Congress and testified against it. He said, don't ever set up a national police force. We can investigate, that's all we should do, because he said, if you set up a national police force, in very short order, it could be the end of our democratic Republican form of government. I had a great admiration for J. Edgar Hoover, worked for him for 16 years, and I found out he was a great American. He stood for very basic fundamental principles. Now, Federal agents weren't even allowed to carry guns for a long time until several of them were killed during the gangster era. Number one was refused, that's J. Edgar Hoover. Number two is killed. A number of agents were killed. Then they had finally authorized them at least to carry guns to protect their lives. Now, civil rights violation is something else. A lot of people didn't understand why the FBI didn't go out and prevent civil rights violations. Well, they didn't have any authority to do that. After they occurred, they could investigate them, but it was the responsibility of the states to protect civil rights. But when 3 of the civil rights workers were murdered and buried in an earth dam, you remember the FBI went in and found the bodies, and there was a prosecution in the federal courts. That's important to understand. We don't want a federal police system, but we do have federal investigations in certain cases. All right, now the founders made the federal courts the guardian of the Constitution. Somebody had to see that everybody kept within their proper boundaries, because you see, we didn't give general authority and power to the government. It was limited, and that's your blank. Capital A is limited. The founders are very concerned about a national police system. Here's what Washington said. Government is not reason. He says it is not eloquence. It isn't a question of getting in there and debating back and forth. No, not at all. It's force. That's what government is. It's force. And like fire, it is dangerous servant and a fearful master. All right, so they had to have somebody to kind of keep everything within their proper bounds. And they decided they would turn it over to the Supreme Court. Now, they expected the court to strictly interpret the Constitution. And that's where we've gotten into trouble, because in the beginning they were strict in their interpretation. They said, we're going to interpret the Constitution just like the founders intended it. And I've quoted Chief Justice Taney here for you, where he said that should be done. And down here, Justice Thomas Cooley, I also quoted him. You must interpret the Constitution the way the founders intended it. And they described what they meant in the Federalist Papers. Well, it wasn't very long before we had the Welfare Clause turned right upside down in interpretation. Commerce Clause shattered in its original intent and meaning, and the 10th Amendment began to be violated, and that's where we are today. We have to go back. We've got a task to do, because at this point in time, we need a judicial reform amendment to get things back on track, and we've got one prepared. But first, let me just quote to you Thomas Jefferson. He saw what was happening. He said, we didn't put enough chains on the judicial system, and I can already see that it is gradually concentrating power in Washington through misinterpretation of the Constitution. And so I gave you there his full quote. It's amazing. He says, it has long, however, been my opinion that the germ of dissolution of our federal government is in the constitution or structure of the federal judiciary, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction, gobbling it up, you see, until all shall be usurped from the states and the government of all will be consolidated into one. And Americans of 1980 and all through the 80s are going to be very much aware of this problem. He says, to all of this I am opposed, because when all government shall be drawn to Washington as the center of all power, it will render powerless the checks provided, and will become as venal and oppressive as the government of George III from which we separated. And people have begun to complain about OSHA and EPA and these other things that are not authorized in the Constitution. Then how did they get there? By misinterpretation. And that's an interesting thing all by itself. So what is the remedy? Well, it has to go in 2 directions. First of all, we've got to have a Congress that is constitutionally oriented, that has studied what the Founding Fathers intended, because the center of their thinking was freedom. Freedom, prosperity, peace, and domestic tranquility. They had that all set up, and now as it's beginning to be lost, it's time to go back. And then you need that kind of a Congress that is constitutional oriented to approve a judicial reform amendment. And here's what it would provide. In fact, it would protect both the people and the states, and that's your blank under number 2. Number 1 is Congress, number 2, states. It would authorize 2/3 of the House and the Senate to overturn a Supreme Court decision. I don't think the Supreme Court would be nearly as reckless as it has been if it had that hanging over its head. And then it can also be done by 3/4 of the states. You know, if the states had had this power, they would have dumped forced busing long, long ago. It was an unconstitutional approach to a problem, and people, both the minorities and the majorities, have objected to that administration. There was no constitutional authority for it whatsoever. It had to be done by misinterpretation, and the courts, we should have had the people able to do something about the courts forcing that onto the people, which they did. And so you have A is 2/3 and 3/4. Those are your two blanks. And B is prohibit. We should have in that amendment a prohibition against the federal government absorbing, as it has been, a lot of jurisdiction from the states. It's been absorbing a lot of state cases it was never intended to take onto the federal level, which is already jammed. The courts are already jammed to the dockets, in the dockets. And we ought to require judges of the Supreme Court to have certain qualifications. In this amendment, we're suggesting that they have 5 years of judicial experience, and that 3 of those be on a state Supreme Court or judge of a federal court. In 1962, Congress was very upset when it found that practically every member of the Supreme Court was just a professional politician with no real judicial experience at all. That was the Warren Court that probably did more to dismantle the Constitution than any court that we've had since the beginning of our country's history. Now, ordinarily a Constitution is set up for one specific purpose, and that's just to describe the structure of a government. You don't include a lot of legislation about what's a crime or what a regulation should be for this or that. No, just what's the structure of government? Then let it decide all of the little things like crimes and regulations. But the founders wanted to put one crime in the Constitution. They were very worried about this one crime. They wanted to simplify it and make it specific, and it was treason. Your first blank is crimes, and your second one is treason, under Roman numeral 3. Now, in England and much of Europe, actually, the Parliament used to use the offense of treason to accomplish some very, very evil things. Number one, they would use treason to hang political opponents, hang the leaders of political opposition. That's your blank, political. Political opposition. And then confiscate their family estates. And many times these were very rich estates, as you know. So confiscate their rich estates, family estates. Now, England alone had 17 different violations which they called treason. Excuse me. Excuse me. 17 is your blank. 17. All right. Now, what is treason in the United States? There are just 2 ways to commit treason, not 17. And 1, to engage in the waging or levying of war against the United States. War. Now, you see, that's what Benedict Arnold was guilty of. All of you remember his case. He was a hero, great military leader. Then he married a Tory girl and got his feelings hurt, and he almost betrayed Washington and the whole army at West Point. All right. He led armies then. He afterwards almost captured Thomas Jefferson, that is, his troops did. All right, number 2 is giving aid and comfort to somebody who's waging war. Those are your blanks, aid and comfort. All right. Now, capital D. Here's an interesting thing. The Supreme Court has held that you don't have an enemy in this technical sense until Congress has actually declared war against a particular country. In other words, if we know that a country is about to declare war on us, and we find some of our citizens giving aid and comfort to it, it's still not treason. Not until such time as a formal declaration has been made. So capital D is war. That blank is war. Now, in 2 of our worst wars, and they were very real wars, we had the strange situation of calling them just police action. Police action, where we had some of the heaviest casualties in the history of the United States. And so number one is police action. You're supposed to be settling a little dispute. Well, they were terrible, terrible struggles in which several million of our young men had to be cycled through the system in order to keep those wars going. The first one was the Korean War, which lasted 3 years, Korea, and then the 10-year war in Vietnam. I tell you, those were terrible wars. But number two there, in both of these wars, prominent Americans ran blood banks for the enemy, gathered clothes for the enemy, and some of them even went over and broadcast over the enemy networks to our troops, and that's your blank, troops, telling them that communism was the only hope of the world and they were on the wrong side. All right, now how can you convict a person of treason? It must be a confession in open court or have two witnesses to the same treasonous act, a same overt act. Not just something that he thought about, but something that he actually did to carry out this treasonable act too. Now Congress is given the responsibility under Section 3 to declare the penalty, and they've said that the extreme penalty for treason is death. But it said you can't work a corruption of blood. Well, what does that mean? That means that you can't penalize a man's family like they used to do in England, where they'd take away the family estate. So family is number one. And during the war between the states, when some who were members of the Union Army then went over and joined the other side, their estates were confiscated as part of their penalty. And do you know when those estates were sold? Their heirs were able to have them returned, because you can't have the penalty extend over beyond the life of the individual who committed the treason. And so that is your second blank there, returned. All right, now this covers the famous Article 3 on the American judiciary. And you can see how important it is, and you can see what the founders were trying to do when they turned it over to the judiciary to be our, what should we say, guardian of the Constitution. And they did pretty good for many years. And then they found out how much power they had, and the courts started using it just like Jefferson saw it in his own day, until now it's gotten around to the point where we need a judicial reform amendment, which I suppose will be considered by the Congress in the not too distant future. And it also suggests to us that we are not helpless. We need a constitutionally oriented Congress to help us, and then we will get our country back on the track. Now, let me just point out now that this is the first half of Lesson 7, and now in our next program together, we will treat the remainder of Lesson 11, the other 4 articles of the Constitution. I think you'll find that very interesting.